Today we'll be discussing a topic that can cause significant stress and anxiety: statutory demands. Firstly, let's understand what a statutory demand is. A statutory demand is a formal request for debt payment served by a creditor. When you owe money, creditors have legal rights to ask for their funds and can involve the court if you aren't complying with the payment agreement. However, when other methods of debt recovery fail, creditors can take a more serious step by issuing a statutory demand. This demand serves as a warning that if you refuse to pay the owed money, it can lead to your bankruptcy, an experience nobody wants to face. Now, you might be wondering if you can simply ignore a statutory demand. Well, the answer is a resounding no. Ignoring a statutory demand is not a wise decision, especially if you wish to avoid bankruptcy. By ignoring a statutory demand, you risk your creditor petitioning for your bankruptcy, which can have severe consequences. It's crucial to take this situation seriously and understand your options. The good news is you can apply to have a statutory demand set aside or cancelled on genuine grounds. Let's explore some of the reasons you can use to apply for the cancellation of a statutory demand. Number 1. During a dispute. If there's a disagreement between you and your creditor over the debt, such as when they claim you owe them for goods that you never received. Number 2. During a counterclaim or countersuit. When you allege that your creditor owes you, under a contract, a sum of money equal to or greater than what you owe to them. Number 3. Incorrect issuing of a statutory demand. If your statutory demand was issued incorrectly, perhaps containing inaccurate details of the debt, or when you believe you don't owe the creditor. Number 4. When you owe less than £5,000. The minimum amount that can actually trigger a statutory demand is £5,000. If you receive a demand for a lower amount, you can apply to cancel it. Number 5. When the debt is statute barred. Debts become statute barred when the time limit for creditors to take court action has passed. In some cases, creditors can no longer serve a statutory demand or any other court papers, and you are not obligated to pay the debt. Now let's discuss what steps you can take when you receive a statutory demand from a creditor. If you feel you don't have any grounds for appealing to the court to cancel it, here are several options that you could consider to help avoid bankruptcy. Number 1, you could clear the debt. If you have the means, clearing the debt entirely is the easiest and most stress-free way to handle any challenging debt. By settling with your creditors, the case ends there, and they won't need to pursue bankruptcy proceedings. Number 2, ask to pay in installments. If you can't afford to settle the debt all at once, you could try reaching an agreement with your creditor to pay it in manageable installments. Explain your financial situation, and creditors often show understanding. They would prefer a payment plan over the costs involved in a bankruptcy proceeding. Number 3, you could ask your creditor to write off the debt. Surprisingly, sometimes explaining your genuine financial hardship to your creditor can lead to a favorable outcome. If you have no income or valuable assets to help you repay the debt, you may be able to ask your creditor to write it off. Creditors understand that pursuing bankruptcy comes with its own costs, and if they believe that they won't gain anything from it, they might be willing to stop legal action and forgive your debt. Number 4, offer security on your property. While this decision requires professional housing advice, it can be an option to avoid bankruptcy when dealing with persistent creditors. If you own a valuable asset or a property, offering it as security against your debt can prevent your creditor from pursuing bankruptcy. The property will be held against the debt, and once sold, the proceedings will be used to pay off the debt, with any remaining amount returned to you. Number 5, set up an individual voluntary arrangement, or IVA. An IVA allows you to freeze your debt and pay it back in manageable installments over a period, typically 5 years, though setting up an IVA may incur expenses. It provides an alternative to bankruptcy for individuals who have properties or steady incomes that they can use to help clear the debt over time. IVAs can be suitable for various types of debt, such as overdrafts, personal loans, catalogue debt, hire purchase debt, mortgage shortfalls, credit and store cards, and more. Number 6, take your debts below £5,000. Another option to alleviate the pressure of a statutory demand is to reduce your debts below the £5,000 limit. Communicate with your creditors. Pay off a portion of the debt to bring it below £5,000. Once the debt falls below this threshold, your creditors no longer have the power to initiate bankruptcy proceedings. If they send a statutory demand, you can easily apply to have it set aside or cancelled. If you're struggling with debt, then there are a number of debt solution options available here in the UK. Some are free to use and others include fees, and each will have their own pros and cons. If you want to learn more about the solutions available, then we've created a really great form that you might be interested in checking out. Click the link in the description below to get started and answer a few simple multiple choice questions, like the total amount of debt, how many people you owe, your living situation, and we'll connect you with one of our trusted partners so you can find out more and take steps towards improving your financial situation.